My name is Matt Landers. I'm the Public Policy Manager here at GSBA. We're very excited to have you all join us tonight for the very first online public policy roundtable that GSBA has done. We are very honored to have Colleen Melody with us here tonight. If you have any questions during the presentation, you can just type them into the chat box at the side of the presentation. I see Karen and Robert have already found it. And then if you lose it during the presentation for whatever reason, you just drag your mouse down to the bottom of the screen, and the little blue button with the speaking bubble in there can get you back to it. I will be off camera monitoring the questions during the course of the evening so that we can make sure they get relayed to Colleen as well, although she has also volunteered to take any of your questions privately afterward if you think that would be more appropriate. So I would like to introduce Colleen Melody, the Chief of the Civil Rights Division in the Washington Office of the Attorney General. Her team investigates and enforces anti-discrimination guarantees in our federal and state constitutions. We were also going to have the Washington State Human Rights Commission with us here tonight, but unfortunately they couldn't make it at the last minute. But Colleen can speak a little bit about their role, and I can connect anybody with their office after this presentation. So I will step off screen and hand it over to Colleen. Thank you so much for joining us tonight.
Thanks, Matt. So I'm Colleen Melody. I am the managing attorney in the Civil Rights Division at the Washington State Attorney General's office. And what we do is enforce civil rights law on behalf of Washingtonians. So we're always the plaintiff. We investigate and litigate our own cases. And so we have lots of experience talking with members of the community about potential civil rights concerns that they have and trying to figure out whether there is a role for the AG's office to play. I also represent the Human Rights Commission as our client. So I'll talk a little bit more sort of at the end about how to contact the Human Rights Commission or our office, but they are a sister law enforcement entity. And when they are investigating a case and have decided that there is reason to believe that discrimination has occurred, they refer it to our office as the prosecutor. So we prosecute their cases, and we also independently do our own investigations and cases that lawyers on my team identify. So Matt and GSBA asked me to go a little bit over sort of the basics, the nuts and bolts of civil rights in Washington, something that you might kind of think of as Civil Rights 101, because there are specific statutes and laws that confer rights on us when we work in this state, when we look for housing, when we do business. And so I thought that I would go through those just briefly, and then it'll probably take 25 minutes or so, and then take any questions that you might have. So I'm going to walk through this. I have this little PowerPoint that helps keep me organized. So civil rights in Washington, sort of what are they and where do they come from? What they are our rights to equal treatment and freedom from discrimination. So basically, civil rights are a guarantee to be free from certain kinds of conduct that is unfair. And what is discrimination that we have sort of the right to be free from? Treating someone differently than someone else, or adopting a policy that affects people differently based on who they are. So it's really two different kinds of things that can be discriminatory. One is sort of an outright or intentional decision to treat someone differently, less well usually than somebody else based on a trait that they have. But then another is adopting a policy that sort of, whether you may intend it or not, ends up having a negative impact on a certain group of people. So let's see. So I annotated this to sort of show that different treatment, maybe refusing to hire somebody because they're African American, or firing someone when you find out that they're pregnant because you don't think that your business can accommodate somebody who's pregnant. You know, doing something that's a different treatment based on something you know about and intentionally, that's intentional discrimination that happens on purpose. But you might have a policy that discriminates against people, and you may not be intending it. So one example that I always give of that is requirements that an employee be able to lift 100 pounds. That used to be really common in certain kinds of jail settings. And those policies are going to have a negative impact on women being able to work in that workforce, and that may not be the intended sort of effect of the policy, but it is the result. And so then where do civil rights come from? So they come from many places, actually. Keeping track of the status of civil rights and all of their different kind of legal contours is definitely a full-time job. We get civil rights from the US Constitution, from our state constitution. Our state constitution provides more rights generally than the federal constitution does. We get civil rights from federal law, including the group of civil rights acts that were passed in the 60s following the civil rights movement and the assassination of Dr. King. And then we also get them from state law, and just like as with sort of the constitutional protections, state civil rights laws are generally better and more protective in Washington than they are at the federal level. So we're lucky that way. Folks who live in other states, Texas and many other states in the South, have really only federal law to rely on because their state law is not protective in the same way that ours is. And then federal and state regulations. So agencies like the Equal Employment Opportunity Commission at the federal level or the Human Rights Commission at the state level can pass laws that explain and sometimes expand upon the definitions that are in the law themselves. And I lost the ability to click through here. Yep. And so then I said at the bottom that there are some sort of basic and shared rules. So the first rule is that civil rights apply broadly when we act within our communities. I'm often asked what areas of sort of conduct civil rights apply to. Where do anti-discrimination rules apply? And my usual response is almost everywhere. It's difficult to think of sort of a public-facing activity that we engage in where there's not a civil rights protection. And so here's a list. Employment, when we search for housing, whether we're buying housing or seeking to rent it as a tenant, or even when you're buying sort of land. In education, whether it's private education or public education, most education except for sort of truly religious entities are covered, and even then they're covered in large part. There's only a few things that are accepted. Public accommodations, which is kind of a legal word for government offices and businesses that are open to the public. So in Washington State, any business that holds itself out as a sort of public-facing, open to the public entity is covered by civil rights laws. Credit interactions, whether you're applying for credit or seeking credit, or insurance, all covered. Voting, and then public contracts. So it's a really broad list. And then my sort of second rule is that discrimination is often at play when it's based on a trait that you can't change or shouldn't have to change. So discrimination becomes illegal when it involves one of these sort of inherent traits that just kind of makes you who you are. And in a previous version of this presentation, I had a image here of the cover of Lady Gaga's Born This Way album, and then somebody told me that it was probably a copyright violation, so I took it out. But that's a good way to think about it. If the discrimination, if bad treatment is happening because of something that is sort of inherent to who you are, that either you don't have any control over or that really you shouldn't be required to change, then it's probably the subject of a civil rights law. And so here's my list. So race, color, and by that, that means skin color. They're from civil rights statutes from the 60s. National origin, so either if you were born in a foreign country or if you just have ancestry that is, not the U.S., which really we all do except for the very few of us who are Native American and have Native American ancestry. Creed, which means religion. Sex, sexual orientation, which in Washington is defined to include gender identity and gender expression. Age in the employment context, so you can't discriminate against older workers. Disability, which could be physical, it could be a mental health disability, and it could be an invisible disability, epilepsy or other things that are disabling but that may not be visible. Honorably discharged veteran or military status, your marital status, or in your status as a family with children in the housing context. So the legislature knows that some landlords only want to rent to quiet, upper middle class professionals with no kids and families with children were having a really hard time finding rental housing, so they made it unlawful to discriminate against families with children in that context. I think this is the same slide. Okay, so then the elements of a civil rights violation, I like to go through these because it's sort of a, it's almost like a math problem. You build a civil rights violation by adding components together. So this is how the equation goes. You need different treatment in a protected activity because of a protected class, and then you're able to sort of make out a civil rights violation. So different treatment is sort of what we talked about before. In the employment context, it's refusing to hire someone or firing someone. In the housing context, refusing to rent to a person or evicting a tenant. In a business context, it's refusing to serve somebody at a restaurant or declining to make a loan to, a particular family. And then you need to add to that the existence of sort of a protected activity, one of the ones we talked about before, this broad list of kind of employment, housing, public accommodations, credit, insurance, government contracting, and then because of a protected class. And so once you have all those three ingredients kind of in the mix and you're able to show each one, then you have a civil rights violation that would allow you to file an administrative complaint, go to court, and potentially have your rights upheld. So then, a couple of kind of details. The public accommodation definition, I said this before, but is incredibly broad in Washington State. So it's really going to be almost any business that's open to the public. And I know that many of the members of the GSBA are business owners, and so there are very few limits on the civil rights applications in public. And I think that's really important, right? Because when discrimination happens in kind of the public square, it happens in public. It's particularly humiliating when you talk to somebody who has been refused service because of kind of a protected class or a protected trait of theirs. They'll tell you how harmful and hurtful it is to have that discrimination happen where others can see it and where sort of strangers can witness an injury to your dignity by being refused service. And so I put some examples up here. I get a lot of questions about the Arlene's Flowers case. And so, a flower shop is a business that's open to the public and was the basis of the Washington State's lawsuit against the flower shop owner in the Tri-Cities. And so, you know, but more than just sort of over-the-counter transaction of goods and services are businesses or entities that provide services. So I put some of those at the bottom there: a medical clinic, a daycare, a cemetery. Places that you might not think of when you think about a storefront that has hours from kind of 9 to 5. But all of them are public accommodations where discrimination is unlawful. Government offices and services are also public accommodations. So, the government is not permitted to discriminate when it operates its public facilities. So I gave some examples there, like public school and public transit, that I think people may not quickly think of when they think about a business open to the public, but it is. It's a service provider where you exchange some sort of funds for service, even if it's through your sort of tax dollars, and they're prohibited from discrimination too. One that's not on here is the police, but the police are covered by the Washington State law against discrimination and are prohibited from acting in a discriminatory way when they're engaged in their official duties. They're also covered by federal law. So a few more details. Because many of you are employers who have 8 or more employees are covered by the anti-discrimination rules. So truly small, truly tiny employers are sort of exempted by the legislature from having to comply with the anti-discrimination laws. That doesn't mean that you shouldn't choose to obey them. It's obviously sort of one of our most important state values in Washington are anti-discrimination, but the legal rule says that employers with less than 8 employees are not covered. You only need 8 employees anywhere in the business or in co-managed businesses. If you happen to say be a landlord and each of the condos that you own and rent out are under a different LLC. If they're managed in common, they'll count together. And we've had situations where an employer was based in Oregon but had one employee in Vancouver, Washington, and but there were 8 employees in the company altogether. And our opinion is that employer is covered because they had 8 employees and at least one was in Washington State. Discrimination includes harassment. So, there's discrimination where you can identify kind of one singular event that was the kind of illegal thing. A landlord who refuses to rent to an African American tenant, or an employer who fires his employee when he finds out his employee is gay. There's a specific kind of thing that you can put a circle around and point to. Harassment is different. It's a course of conduct that inflicts repeated sort of injuries over time, and the cumulative effect of those injuries is itself the action that creates the harm. And harassment is covered by Washington law. Harassment based on any of the traits that we've talked about, so disability harassment, sex harassment has been so much in the news during the Me Too movement, all covered by the Washington law against discrimination. Religious schools and employers are often exempt. That is true, provided that the thing they're doing is religious in nature. And so, truly religious educational institutions are not subject to the Washington law against discrimination in their sort of admissions policies or in their employment, as long as the employment is of a religious thing. So I'll give you an example from a real case, which is that there was a hospital that fired a janitor after sort of giving him a hard time about some disability related issues and other things. And he filed a lawsuit claiming that it was race discrimination. He was an African American gentleman, and disability discrimination. And the hospital said, we're a religious hospital, so we're exempt from the anti-discrimination rule. And what the court found, the Washington Supreme Court found, was, well, not as to the janitor, you're not. It'd be one thing if you were hiring a priest, or if you were hiring someone to, provide last rites for hospital patients, perhaps. If you are somebody who's making policy based on kind of the religious views of the hospital. But a janitor doesn't have anything to do with kind of the religious mission of the hospital. And so as to that employee, you are not exempt from the WALAD, and he can bring his discrimination lawsuit forward. And then the last thing is that sometimes reasonable accommodations are required. Reasonable accommodations are a special kind of civil right that the legislature at the federal level or at the state level can grant to people, where we think that an employer or a housing provider should be required to really try to make it possible for an employee or a tenant to live there and sort of be successful. And so reasonable accommodations apply to religion. So if an employee needs extra breaks because they need to pray more often during the day, or they need a special diet at work, and the employer ordinarily provides all the food at the work, and the employee needs a special diet. Those are examples where accommodations will be required, and the employer needs to do a little extra in order to make sure that the religious employee can be successful. The same is true with housing. And the same is true in the disability context. There's a brand new law that my office also enforces called the Healthy Starts Act. It was passed in 2017, and it extends this right of reasonable accommodation to pregnancy and pregnancy-related health conditions. And so we have been enforcing that law since it went into effect in 2017. So those are sort of some details about Washington law, but generally, the sort of equation that I put up is the one that we work with every day, where you're looking for kind of different treatment based on a protected class in a protected activity. And when we see all of those things together, we know that we have a civil rights problem. So what do you do if you have a civil rights complaint, or if you think you might have a civil rights complaint? Well, one thing you can do is contact the Washington State Human Rights Commission. Their website has different tabs for different categories of complaints that you might have, so employment or housing, for example. There are time limits that apply to complaints with the Human Rights Commission, so it's important to kind of act quickly a little bit if you think you have a Human Rights Commission complaint that you might be interested in filing. So for everything besides housing, so discrimination at a business, at a government office, in employment, anything like that, the time limit is 6 months after the act occurs. So you want to get right on it, and it's a year for housing. So there's a little bit longer period by law for housing complaints. You have 1 year. The Human Rights Commission takes complaints. They have a electronic form that you can fill out, and they take complaints over the phone. They can help you work through the complaint process, including with their toll-free number. And you can also contact our office. So generally, what the Human Rights Commission accepts complaints, and they let us know if there's a complaint that may have impacted more people than just the one complainant. Our office in particular takes cases that involve a pattern of conduct, a policy that's at issue that's illegal, because policies by their nature affect more than one person. They're going to be generally applicable. And so we're often interested in taking those kinds of cases where the impact might benefit more Washingtonians. We also like cases that are either novel in some way because it's an issue that hasn't arisen before, or there's not a lot of law about it and we think there should be. Those are cases that we tend to take on my team. And then cases where, for whatever reason, the government really hasn't spoken up for that group of people before, where we're not aware of cases where the government has come to lift up and hold up the kinds of rights that we think exist and that we think sort of should be, really should be affirmed, right? And so if there's a case where we think that there's an important civil rights issue and we don't think that the government has been particularly active in it, those are cases that we look closely at. Our office, my team, puts together a civil rights resource guide. It's online. We update it. That's what it looks like. And you can find it at atg.wa.gov. That's our public-facing Attorney General website. Under the tab that says Serve the People, there's a link for the Civil Rights Division, and this guide is one of the first thing that pops up. But it has a lot more detailed information than I have covered here about the specific ins and outs of employment law, the specific ins and outs of housing law, and other kinds of resources that are available, either to make a complaint or to just find out more about what your rights are. And so we encourage folks to check out the Civil Rights Resource Guide. That's also the place where you're going to find contact information for my office and my team. So that's sort of, basically in a nutshell, those are Civil Rights 101 in Washington State. And I'm sort of happy to take any questions that people may have about what the law covers, what the law doesn't cover, and how you can raise a civil rights question if you have one. Mm-hmm.
All right. So thank you again, Colleen, for joining us. I've got a couple questions to start us off. Washington State is an at-will employment state. I think we're one of the few left there. How do you balance at-will employment, where theoretically an employer can dismiss an employee at any time for no cause, and civil rights violations? Yeah.
So even in at-will employment states like Washington, you can't dismiss an employee for discriminatory reasons. So that it's an exception to the rule, right? And that's true, nationwide, because there are federal protections that prevent discriminatory employment actions. So in any state nationwide, there are certain things that you just can't do, cannot be the basis for terminating an employee. And in Washington, the civil rights protections in the Washington Law Against Discrimination stem from 1949. So it's just a really long-standing rule in the state, and the courts are very aggressive about making sure that sort of the at-will framework that we have in the state doesn't eat holes into the civil rights protections that we've had for decades and decades. Yeah.
And then you mentioned the Arlene's Flowers case in your presentation. You said you get a lot of questions on that. It's something GSBA certainly has been following very closely. With the Supreme Court of the United States kicking it back to Washington, do you believe that anything will change based on the Masterpiece Cake Shop decision out of Colorado that the Supreme Court was talking about, but then said that Arlene's Flowers had to be looked at again for those reasons?
I don't think so. I think that our case was very different from Masterpiece in that the flaws that the U.S. Supreme Court found in the proceedings in Masterpiece, I don't think are present here. So what that case ended up turning on, when the U.S. Supreme Court agreed to take that case, everyone thought it was going to be this sort of like blockbuster decision that was going to resolve what happens when rights conflict. When someone has truly held religious beliefs in their business, and you have a customer who has the right to access goods and services without discrimination, what happens when those things sort of come head to head? And the court didn't answer that question at all. What the court did was find that there was some impropriety in the proceedings before what is kind of the Colorado equivalent of the Washington State Human Rights Commission, and said that that body had evidenced and sort of demonstrated hostility towards the baker's religious beliefs, and that so tainted the whole proceeding that it had to be thrown out. And so then the U.S. Supreme Court said, hey, Washington, go back and look and see if those same kinds of problems existed in the Arlene's Flowers case. And there's two things about that I think are important. One, our case didn't go through the Human Rights Commission. It was brought as a lawsuit by the Attorney General's office. So you're not going to find that same record of proceedings because it just didn't exist. Yep. And second, I don't think that we, of course my view is this, but I don't think that we've ever been anything but respectful of Ms. Stutzman, the flower shop owner's religious beliefs. We don't question that she has sincerely held religious beliefs. We just think that Washington law means that she can't impose those on customers in her store. But I don't think that it would be fair to characterize our office as somehow disrespectful of her religious beliefs in the way that was a problem in the Masterpiece case.
And then as you were going through the list of protected classes, civil rights classes in Washington State, you did say that in Washington, gender identity is generally considered under the definition of sexual orientation. Is that a hard and fast thing? Is that a kind of loose thing? We've heard that when a lot of laws in Washington reflect this language out of the Washington Law Against Discrimination, particularly the trans community and the gender non-binary community is very concerned that they aren't being represented here. Can you speak a little bit more about how gender identity and expression are recognized under the Law Against Discrimination?
Yeah, so they're definitely covered. The terms gender identity and expression are in the statute, and I don't think there's any question that they're covered. The quirk of it is that they're included as part of the definition of sexual orientation, and that is that's imprecise, right? That's not right, and we know that. But this was sort of a function of the way that the statute was being sort of passed and amended in 2006, when sexual orientation, gender identity, and gender expression were all added as protected classes under the Washington Law Against Discrimination. I'm not sure why the drafters, they chose to put that in there. It may have been because that was a better way to get more protections included than by singling them out and sort of having a full debate about each one, because then maybe you lose one, right? Maybe gender expression or gender identity don't make it through. I think in 2006, people knew that they knew less trans people than they know now. And so there was a way to maybe usher in protections for the trans community that people were maybe more comfortable with or understood better around LGB people. And that's my suspicion. I don't actually know, but there's no question, there can really be no question that trans people are fully covered by the Washington Law Against Discrimination, even if the place where their protected class is listed isn't maybe the place where I think it may make the most sense.
Thank you. Mm-hmm. Let's see. Carlos, do you have any more questions up there? All right, Colleen, do you have anything else you would like to add tonight?
Just reach out. State government is small, and I think that you'd be surprised at how easy it is to get a hold of somebody at the Washington State Human Rights Commission who would like to answer a question for you, or to contact my office. There's a way to email us questions directly, and the inbox is manned every day, and someone will answer your question. So we encourage folks to reach out if they have any questions about what their rights or responsibilities are under civil rights laws.
All right, well, thank you so much for joining us tonight, and thank you everyone online for joining us, and we will be reaching out to hear how you experienced this first online policy roundtable, and we hope to see you again soon. Have a great evening. Thank you.
Bye.